If you're a state of California employee facing disciplinary action, it's important to know your rights, the process, and where to get help. I'm Brett Sherman from Goyette, Ruano, and Thompson, and in this video, I'm going to be going to an overview of the appeal process. If you find the information in this video beneficial to you, or believe it may be beneficial to someone you know, please hit that like and subscribe button and share the video. If you've received disciplinary action, the first call you should make should be to your representative. If you don't have a representative, you should make arrangements to obtain representation. Your representative should be someone who's gone through the process before and knows the entire appeal process. The attorneys here at Goyette, Ruano, and Thompson have represented countless employees in your same situation, from the Skelly process through the State Personnel Board hearing. Prior to the discipline being imposed and a State Personnel Board appeal being filed, you have the right to what's called a Skelly hearing. A Skelly hearing is a pre-disciplinary meeting whereby you have the opportunity to tell the employer why the disciplinary action they are intending to impose should not be imposed upon you. The Skelly hearing is voluntary. Oftentimes they are attended, sometimes they are waived, but that's a consideration you should make after discussion with your representative. Should disciplinary action still be imposed by your employer, you have the right to file with the State Personnel Board. There are strict time frames involved with the State Personnel Board appeal. More often than not, the disciplinary appeal deadline is 30 days from the effective date of the adverse action. However, depending on the case, the appeal deadline may be much shorter. After the appeal has been filed, shortly thereafter, you and your representative will receive a notice of a pre-hearing and settlement conference, oftentimes called PHSC. This is a critical step where both sides will meet with an administrative law judge from the State Personnel Board to try to settle the case. 12 days prior to the PHSC, both sides will file a PHSC statement, which contains, among other things, a list of potential exhibits, a list of potential witnesses, procedural issues that may arise in the case, and dates for a potential hearing if the case does not settle. The filing of this pre-hearing and settlement conference statement is crucial, as failure to list a potential witness or a potential exhibit can lead to not being able to call that witness or introduce that exhibit at the hearing. At the pre-hearing settlement conference, after the judge has had a chance to discuss both sides with each party and the strengths and weaknesses, the judge will see if there are any settlement terms that are acceptable to both sides. If the matter settles, the administrative law judge prepares a proposed decision for adoption at an upcoming State Personnel Board hearing. If the administrative law judge is not able to obtain a settlement that both sides are amenable to, then the matter is set for a hearing. The hearing will be set within the next couple of months, but traditionally no later than 90 days from the date of the pre-hearing settlement conference. So if your matter does not settle at the pre-hearing and settlement conference and is set for a hearing, it will be heard before a different administrative law judge than the administrative law judge that heard the pre-hearing and settlement conference. The rules of each hearing vary, once again, based on the type of the case, but traditionally, in an evidentiary hearing, the employer will have the burden of proof. Because the employer bears the burden of proof, they traditionally have the first word and the last word. Now, what does that mean? At the hearing, after the case is opened and the hearing is on record, the employer will have the chance to state an opening statement. After the employer makes their opening statement, you, as the appellant, have the opportunity to make your own opening statement. After appellant's opening statements, the case then turns to the respondent's case in chief. Now, the respondent's case in chief is where the respondent employer will bring evidence against you, and that's in the form of witnesses and exhibits. Now, for every witness that respondent brings forth to testify or question to elicit evidence in the form of testimony, you as the appellant have the ability to cross-examine those very same witnesses. After the respondent introduces their case in chief through testimony and through exhibits, the case will then turn to the appellant to then present their case in chief. That is where you as the appellant also have the ability to introduce testimony, introduce exhibits. Now, if you introduce testimony through witnesses, the respondent will have the same opportunity to cross-examine those witnesses. After the appellant's case in chief, the respondent will then have an opportunity to put on rebuttal evidence, which is a time to rebut any evidence put forth by the appellant. Following the rebuttal, if there is any, by the respondent, the case will then shift to closing statements. Since the respondent employer has the burden of proof, they will do their closing statement first, followed by the appellant's closing statement, followed by the respondent's rebuttal closing statement, which is limited to only discussing things brought up by the appellant in the appellant's closing statement. After the conclusion of the hearing, The administrative law judge will then draft up a proposed decision. Now, this proposed decision is not the final decision, but rather the proposed decision drafted by the administrative law judge. It will then go to the state personnel board for approval, rejection, or modification. I hope you've enjoyed this video on the brief overview of the state personnel board appeal process. If you're going through a disciplinary appeal, or someone you know is going through a disciplinary appeal and needs assistance, please click the link below or fill out a form, and we're here to help.